So I thought I would just start out by talking a little about, you've got the agenda, you sort of know how the day is going to go from a topical perspective. For each of the sections, it's divided up. We're going to hear from the different council. We're also going to have it sort of interactive up here, talking point by point on each of the different arenas that we're going to be covering. And as much, because it's a smaller group, I think we can keep it pretty interactive. So I would encourage you to raise your hand, get my attention, with the exception of if we are in the middle sort of a demonstration, in the middle of somebody's opening, in the middle of a closing, in the middle of something that's clearly a demonstration, if you'll hold your comments or questions at that point, and I'll come back around and pick them up. But other than that, particularly even in this just discussion section during each of the arenas, please feel free, just raise your hand and I will get to you, because I think given the size of the group, that's going to be a good way to keep things flowing. I'm going to turn it over to Wendy here in just 1 second to kind of run the first part of this section in terms of leading the discussion, but I just wanted to ask a few things. I know from looking at the profile of everyone in the room, how many people here, just talking about this first section, we're going to talk about jury selection, I'll say voir dire because I do a lot of work in Texas, but of course up here I'd have to say voir dire. How many people here have picked a jury before? Okay, great, yay. How many people have picked more than 10? Okay, good. All right, good. That's good to know. Okay, how many people here have been on a jury? I was on a jury too. That was kind of an interesting situation. You know, what do you do for a living? I'm a jury consultant. What does that mean? Well, I help lawyers with their voir dire. I got this blank look from the counsel asking me questions, so that was, and they left me on, which was obviously, which was a huge mistake. I swung the jury. That's a whole different story. I'll tell you all about that later. Anyway, okay. So we're looking forward to the day. I think I can speak for everybody. Thank you for coming. We're excited about it. And I think with that, I'm going to turn this over to Wendy to kind of lead this part of the discussion.
Okay, great. And my plan.
Are you walking? Do you want this? We can trade this.
I'm doing a bunch of stuff. So yeah,
okay,
of course.
Good.
The plan, I'm just going to put this down for now.
Okay.
My plan was to use this PowerPoint just as a vehicle to work off of for us to talk about the different issues with voir dire. As you know, this is there's no science to voir dire. This is purely art. And everyone now has told us that they've picked juries, and they know that I'm sure that everybody's made a mistake when they've picked a jury, and they've either gotten really lucky but with their mistake, or they've not gotten so lucky with their mistake. But you know, the jury is outcome determinative, so we need to pick the best jury we possibly can. I think we'd all probably agree. It might be the only place where the plaintiffs and defendants agree today, but I think that's something we will agree on. Okay. So the purpose of voir dire, why is this not doing this? It's supposed to do this really cool thing. I love technology. It worked before. So there it goes. Okay, so the purpose of voir dire is to get inside the potential jurors' minds and to find the jurors' beliefs and opinions that will be outcome determinative. You need to determine what the pre-existing beliefs are when they come into the courtroom, because you know you're not going to persuade them out of those beliefs. You have to acknowledge that what people believe is true is what they will always believe is true, and it's going to be, and you cannot persuade them out of certain firmly held beliefs. And what I believe you need to do is I believe you need to identify those jurors during voir dire, understand what their firmly held beliefs are, and then understand whether or not those jurors are going to be good for you or bad for you. And if they're going to be bad for you, you need to figure out ways to exclude them for cause, or at least use your peremptory challenges. Bill, do you agree?
Yeah, no, I couldn't agree more on that. I think, I always used to tell people you can't cheat physics. I mean, people don't become different people in a jury box. In fact, the anxiety and the stress associated with it kind of changes the way they collect information, perceive information, and act on it. But you can't teach a jury something they don't want to learn. And so you've got to figure out what their life experience is, what their perspective is, what their values are. But I think more importantly, before you get there, you have to understand how your theory of the case and your narrative lines up against certain values and life experiences so that you can figure out who the kind of people are who are more or less likely to accept and advance that theory. Because I think the whole, and we'll talk about it, I'm sure, throughout the day, the whole point of the trial practice is to find a narrative that confirms those life experiences and perspectives, not tries to talk people out of them. Because I agree, you're never going to change people's core values in a 2-week, 6-week, 8-week trial.
And at the risk of touting something that my firm does, but I do believe in a great deal, and that is pretrial research. I'm sure a lot of you here have done mock trials or focus groups or some other sort of research to learn about your case. And that's a key component of it. I always say, you can't convince everybody of your case, but I do think that once you've got your case narrative crafted in the best way that you possibly can, which is part of what you learn when you do focus groups and mock trials, what themes and theories of the case inside the fact pattern and the arguments that you have, but how getting that crafted in the best possible way and then using that data to determine who are the people that no matter what, you're not going to sell your case to them, because there is a group of people that you're not going to sell your case to no matter what. And so I think the idea is to make that group of people as small as possible. That's the thematic crafting of the case. If you do that successfully, you'll sell it to more people than if you're unable to determine what the best way to frame the case is. Did that make sense? I think you have to do,
I completely agree. I think you have to do pre-trial research on potential focus groups. And you can do it as cheaply or as expensively as you want and as the case will dictate. You can do it very simply now with things like eJury, and there's lots of internet methods of doing pretrial focus group research where you can test an idea or test a value and see and put together a theme or a pattern and see if that works and whether that resonates with your potential jury pool. And you can do it. So you can do it pretty cheaply, like within a range of a couple $1,000s, probably less than $2, or you can spend upwards of $25,000, $50,000, $100,000. Depends on whether you're Big Tobacco or you're mom and dad who lost their kid in a car accident. So you have to figure out who you're representing and what's the potential value and what you can afford. But you definitely can do this, and I think it's really critical that you figure out what themes are going to resonate with the jury and what's not, and what was the thing that is going to make them want to get off the jury. The other thing that I learned from doing the pre-trial focus groups in big pharma cases is that people immediately say, "It's not me. I didn't do this. I would never do this. My wife would never do this, my kid would never do this, I would never allow anybody to do this, it's just not something I do." It doesn't matter what that was, that the allegation is. So it could be something like, the breast cancer victim who didn't go to get a second or third opinion, but when we do social science research afterwards, almost no one goes to get a second or third opinion. Or it could be the person who says, "Oh, I read every label, cover to cover of every drug I buy every time I get it from the drugstore." Now, social science research says that's absurd. So we know that there are certain things that are just not true, but people hold certain beliefs and as if they are true, even though they're fictions. And you need to figure out what those are before you walk into them, so that you can confront those and then deal with them. Either address them or find the jurors who will hold those beliefs so deeply that you can try to exclude them.
Right. And I think that's right. And I think the most important component I think we're all saying is that if you go into jury selection sort of blind, or if you don't know from a thematic perspective who you're looking for that you want to keep, if you can. I mean, and we all know it's a deselection process. But even more importantly, you want to know what are the attitudes and beliefs that you want to make sure you get rid of. And you've got to know what those things are. Whether you do pretrial research or not. Pretrial research, I agree, can be a luxury in some cases, but some of it is also just putting your head to it and thinking about,
what you need to consider in that regard. And I'll also say at the outset quickly here that with regard to jury selection, demographics are a dangerous way to go. You need to be considering attitudes, beliefs. People have long-held attitudes and beliefs, and like Bill was saying, they don't let go of those things. If somebody comes in who has just a core belief that, people suing are just out to get money and they're not willing to actually look to see if there's harm, that person's very unlikely to change that view. That's just an example.
Okay. So now we have to deal with the first two questions. Actually, there's a question that came up when I was talking to Bill earlier that's really the precursor question, is that I am a great believer in as much voir dire as you can possibly get, and I think Bill is of the opposite view.
I'm agnostic for this reason. From a defense perspective, you obviously never, ever get a chance to make a true first impression. So anything you're doing as a defendant is, by definition, defensive. From an empirical research perspective, in theory, if I have a well-defined or well-refined theory of the case, and if I have done the kind of in-venue research that tells me a vast majority of people on the veneer agree with my core theory or disagree with it, I could persuade myself, both as a lawyer and even on the client side, that voir dire might actually do more harm than good to my client's case, because it might give my opponent more time to reveal or expose jurors who are more strident or more likely to be effectively challenged for cause. It might reveal jurors who are easier to identify and deselect. And so I say to myself, and then you get into the whole proficiency and competence of it. I mean, no matter how good and how often defense lawyers try cases, quite frankly, plaintiffs lawyers, people who do predominantly a plaintiff's practice, try more cases, pick more juries, and do it, in the first position, not the defensive position, more often. So at some point you say to yourself, gee whiz, why am I doing this? And you say also that in federal court all day, every day, juries get picked that return, viable and fair verdicts without a lot of voir dire. You just have to, I think it's a question you have to ask yourself at some point, why am I doing this, and is it really likely to advance my theory of the case or help me find the jurors I'm trying to find?
I'm kind of in the middle, because I do a lot of work in federal court where we have, at best, 30 minutes aside, which is actually pretty luxurious for federal court, and I see juries get picked that I am very confident in with a small amount of voir dire all the time. But that being said, I like to hear from the panel. I like to know everything that we can. I like as much time as possible. I think your point is also an excellent one, because I think it also depends on a lot of things. Depends on how skilled your opponent is at voir dire. It also depends on the judge. I had a case recently with a new judge in Dallas, and we were defending a medical malpractice case, and the judge brought in a huge panel, and there were 50 some odd jurors that went for cause. They were moved for cause and struck for cause by the plaintiff, and the defense was granted 1. And that had to do with the judge. And so that was a prime example where, to your point, we actually ended up prevailing in the case, and we were okay. But we were not happy about that. That was a case where we would have been better on the defense side had we had less time.
But it's interesting that in federal court versus state court, there are different rules that apply. In state courts, typically we do our own voir dire. In Pennsylvania, in New York, in California, we're allowed to do voir dire ourselves. We're allowed to engage in voir dire even without a judge present. In New York, it's done without a judge present, where you sort of reserve certain questions and run up to the judge at the end of the day and say, well, I have these challenges for cause based on this testimony, and then the judge can call those particular jurors up if he or she has a question. In Pennsylvania, sometimes it's done with the judge supervising, sometimes it's done alone as well. And in California, it's done in the same way. Sometimes the judge is present. The judge will ask a series of questions, will hand out a questionnaire, give you an overnight to look at the questionnaire and then allow the lawyers to follow up with the questionnaire and ask questions based on the questionnaire, and give you 2.5 hours, 5 hours a day, 2 days, just depending on their schedule. And also depending on what's happening in another courtroom, where judges sometimes start one trial and another trial at the same time, or finishing up another trial, so that if that other trial takes a long time, you have as much time as you want to do voir dire. Where in federal courts, we've been confronted with very limited voir dire, where judges are not permitting us to ask any questions at all. And we have been engaged in a long battle with Big Tobacco over precisely this issue, and Tobacco had initially said to us, oh, no, we wanted to use this extensive questionnaire and we want to do voir dire, and now they've flipped and they've taken the position that that extremely limited voir dire is just fine, that they essentially don't want to ask any questions. And I think that's because they've come to believe that the jurors in the areas in which the post-Engle cases are being tried in northern Florida are so biased against smokers, and especially cases involving deceased smokers whose families are bringing the cases 20 years after the time of the death, that they're better off having no questions, because it would give the plaintiffs an opportunity to exclude. So, go on to the next. So the second issue, though, I think the biggest question, and the question that I've talked to lots of, when I prepared for this, I asked a lot of trial lawyers who are friends, well, what do you think? Do you think that you should argue your case to the veneermen and women when they come into the room? Do you start at the very beginning arguing your case and taking that position throughout the trial? Or do you just use your time to find out the bias and the prejudice and strike the ones who will hurt your clients? And the debate is huge, and everyone is convinced that they are right on either side. So, Bill, what's your opinion?
I'm not an arguer for this reason. I think it takes time to get permission, so to speak, from a juror to tell them something that you believe that may or may not be what they believe. And so I would much rather spend the time in voir dire figuring out who you are. You know, how do you live your life? Where do you live your life? What do you do in your life? Because those are the questions they're going to tell me about your core values and your predispositions, not trying to persuade you that the evidence that, you know, I'm going to tell you about in 2 days in an opening statement that you're going to hear over the course of 5 weeks and then argue at the end of the case is going to persuade you we're right. And I want you to figure out we're right before I have to tell you we're right. And the way you do that, I think, is to first figure out what kind of person you are, because there are certain kinds of people who I know will never listen to me. Ever. It's just there are certain people in your life you know are going to be more interested in who you are and what you have to say, and less interested, or who are more like you or less like you, or are going to be skeptical of you or accepting of you. And if I can figure out who those people are, then I think I have a better chance of putting a jury together that's going to listen to our theory of the case and advance it. So to me, that argues in favor of query, not argue. I just don't think that. I don't think it can't be done. I just think it's a very high-risk proposition, especially for a defendant that early in a case.
What's your view on that one, Wendy?
Oh, my view is that you should my view now is that you should ask questions about biases and prejudices, and you know, that this is the argument about arguing your case from the minute you walk into the courtroom, and that's the view I used to hold, as a matter of fact. When I was a prosecutor and then a criminal defense attorney, and then tried some cases for the defense, I actually believe that a lot. And I've come to see the world in a new way lately as a plaintiff's lawyer.
But I think, too, that, I mean, it depends on how you define argue. I mean, there's a lot of arguing that occurs in just how you present yourself, how you sequence your questions, what kind of questions you ask, and how you react to them. I mean, that conveys a lot of the same kind of information that an argument does, in a less threatening and probably more persuasive way.
Well, I actually think that we all probably are talking about the same thing in that regard. I mean, we certainly are going to stand up and say, you know, I'm proud to represent, you know, Mr. and Mrs. Jones who lost their son, and this is a case about the loss of their son. And then the judge is going to tell you not to be concerned and do not bring sympathy or into this courtroom. We don't want sympathetic jurors. We want jurors that will follow the law. I know you will have everybody's going to be sympathetic for a mom and dad who've lost their baby. That's arguing my case. At the same time, I'm trying to find out who are the jurors who are going to be good for me and who will be truly sympathetic, and who are the jurors who are not going to be sympathetic at all, and who I want to get out of the courtroom as quickly as possible.
The thing I've seen too, and I've seen the debate as well, and having been around a lot of different lawyers, plaintiff, defense, and having been involved in a lot of discussions like this, and there's still a pretty large debate about this whole argue the case versus query. And the thing that I've seen in watching, hundreds of actual jury selections, and is I think it makes jurors very uncomfortable when they're being asked to agree or disagree to something that you're really just in some ways trying to get them to make an admission on something that you want them to believe. And I find that jurors, I watch them be uncomfortable with that because they know they don't have enough information at that point to make the decisions that a lot of times attorneys are asking them to make. And that to me is the real danger, is putting the jurors in a place where they're feeling uncomfortable, or they're feeling like you're trying to get them to agree with your perspective, rather than asking them just outright, sir, what do you do for a living? What do you like about your job? What's the thing you like best about your job? People like to answer that question. They like to talk about themselves. They like to be asked questions that they can actually answer. And so I think the discomfort that I've seen on jurors is a big reason not to focus so much on arguing. And of course, you're right. There's places where you're going to intersperse it. But even then, I think that whole process is about listening to them, looking at them. That's a way to build rapport with jurors, and then and getting the information. It's your only chance. It's your only chance to talk to them.
So voir dire means to see and to speak, and courts and commentators have long stressed that it's critical to obtain a fair and impartial jury, and that it's a constitutionally mandated right. And so then, when the court conducts the voir dire and does a limited voir dire, and there has been issues with the limitations, you have to preserve your rights there. I know that no one wants to talk about their appellate rights, but you must preserve your rights at jury selection. If the judge is conducting the voir dire exclusively, as in federal court, you have to be careful and make sure that you have preserved all of these specific issues about getting the prospective jurors' histories and personal prejudices, making sure they're revealed, and that's especially true in a high publicity case. It's got to be probing enough to uncover specific prejudice or bias, and you need to really target this in. So if you have a case, if you're trying a case like the Sandusky case in upstate Pennsylvania, and the judge is conducting all of the voir dire in that case, then you have to be sure that while he's doing it, that he's getting to all of the questions that go to the pretrial publicity issue. And then if he's not, you need to preserve your rights precisely at those points, because that can be reversible error. And also, on the flip side of that, if you're convinced that the case is already going in your favor, you have to be sure to make sure that the judge creates a good record, because you don't want your case to be reversed.
Yeah, and in some venues, you can waive a record of jury selection. Don't do that ever. I had a case where we had a juror who, after the fact, we found out was a rogue, basically a rogue juror, and we had notes that he had lied, which in that state really should have pretty easily been grounds for a new trial, but we didn't have a record. So we had to literally go back to attorney's notes, my notes, to try to build that case, and the trial court actually denied our motion for a new trial on those grounds. We got it later, but we had to go up to get it, and I think had we had the record, it was a lesson for me to not waive that. You don't know what's going to happen, and you want a record of what goes on in jury selection.
Bill?
No.
Okay. And then when pretrial publicity is a factor, a juror's conclusory statement of impartiality is insufficient. And that's pretty consistent. This is a Fifth Circuit case, but I found Ninth Circuit cases, 11th Circuit cases, all on the same point when I was looking at this issue. So if you do have a case that there is a lot of pretrial publicity surrounding the case, like the Sandusky trial or like the Vioxx trials that Mark Lanier tried, then you have to be sure to probe and make sure that the water cooler opinions are not the opinions that you're going to get from the jury. So it's very important, and if it's going to be a judge-conducted voir dire and you're not going to have an opportunity to engage in any voir dire, you've got to make sure you've given the court enough questions that will probe that, and that you object if he or she doesn't ask those questions of the jury or the veneer. So when you're actually selecting, I think that the first question that you need to figure out is who's going to be the leader of the jury. Because whoever the leader is going to be the person who's going to control the outcome for your case, for the most part. And if there are two leaders, that may dictate a mistrial. So I think you really need to look and figure that out first. So you need to advocate. You need to figure out who's going to advocate for your client in the jury room, who will hurt you, and if that leader is likely to hurt you, you need to figure out a way to exclude them.
Yeah, I think one of the most complicated and confounding factors in jury selection is this whole question of leadership versus attitudes. I mean, once you get past people's attitudes and values, you still have to account for leadership, because the one thing, and I'd be interested in what Tara thinks of this, my one frustration as a longtime user of jury research in all forms is it was very exquisite at times in telling you what certain people felt or how they thought or how they reacted to certain things, but it never told you what happened when this person, that person, and the third person got in a room and started doing it together. The whole group dynamic was never accounted for, and is never accounted for in a lot of what we call jury research. So, the conventional wisdom is jury selection is really a deselection process. But I think Wendy's right. There comes a point where you have to actually select a leader, or you have to actually make a strike decision based on leadership as opposed to just attitude, where I'm willing to accept a juror who I think might actually not be my kind of juror, because I'm more concerned about making sure somebody who I think is going to be a leader, is going to drive the jury, is either on the jury or off the jury. So I think this is one of the black boxes that even consultants haven't really jumped into as deeply as they might. Well,
and the problem with it too is it's impossible to replicate, because it's personality driven. So in the sense that let's say we do a mock trial, and it's part of the reason we do multiple panels. So if we do a mock trial, we'll do 3 panels instead of 1, because not inevitably, but often, you might have one panel go completely off in one direction because of one person. So that is in no way, that doesn't replicate what you're going to see necessarily or at trial, or it's just because it's personality driven. So that's the challenge, but I think the reason that mock trial data is still helpful to you is because we have 3 panels. I mean, that's part of the reason that we build in more panels and more people, and just so that we have the collective wisdom of all the people to tell us thematically where we're going. But it's a concern. I mean, when you see, and I see it happen frequently in mock trials where you have one person just hijack a deliberation group, and then it really brings home to you that can absolutely happen in a real trial too, and I think does somewhat often, and it's all the more reason to really watch who those people are. I'm always a big personality, a big leader. Even if I think they're going to be good for us, I figure they're going to get struck by the other side. But it always worries me a little bit to have somebody that I think would run away with the whole thing. If I'm trying my case, or if my client is trying their case to one person, that makes me nervous any day of the week. So.
But you have to understand and appreciate that there are certainly going to be leaders in that courtroom. So I think that you need to figure out what kind of person is going to be the leader. And I just wanted to give you some examples. So you might want to ask, how many of you have held positions as an officer or president, director, vice president, or secretary, treasurer of any organization, like the PTA, your church, your school, a civic organization? Then they'll put their hands up. So okay, so then we know we have these leaders. How many people are the head of a department or the head of a group or manage people? Put their hands up. You can figure it. Then go back and say, okay, what kind of work do you do? I'm a deputy prison warden, and I supervise 100 guards and 1,500 prisoners. Next juror says, I'm the head of an English department, and I supervise 3 professors and, some secretaries and some students and some grad students. And then the third person says, well, I run a McDonald's at night, and I have 10 people who I'm responsible for. I work the Monday to Friday. It's a big shift. It's the most busy we are. We're right here on 6th Avenue. And, okay, so now you have 3 leaders in your potential group. Now, assuming all else is equal and that they are otherwise equal for you and after all the other questions, you have to decide which of those leaders do you want, because one of the 3 is certainly going to be the leader among the 3 of them. So who do you think? The prison warden, the professor, the head of the department, or the McDonald's guy who actually has a tough scene running 10 people at night at McDonald's on 6th Avenue? Typically, I think that when we did this exact little study, we found that it was the English professor, because he's the one that's perceived as having the most power. He has the fewest actual reports, but he's perceived by this group as having the most power and the most intellect, because because of his education and because of his position and stature in the community. So you sort of have to think, once you figure out who the leaders are, you have to figure out what the dynamic is going to be among them.
I'd take the McDonald's guy almost every time, on the theory that it's a tough job. He's got to manage a bunch of different personalities. It's probably a very diverse employment group, and it's a job that I'm sure has some lighter moments and is kind of fun, but has some tough moments, has some ups and some downs. And I would look at that and say that guy's probably a pretty solid citizen. The deputy prison warden, I'm sure, is underpaid, put upon, and overworked, and not a content, happy person. And the English professor, there's no defense lawyer on earth is going to put an English professor on their jury.
I was going to say, it's hard for me to even think about that, because I need to know which side am I working for, and then I need to know the answer to about 5 other questions to add to that, and then I could tell you what I think.
So then the question is, we need to figure out who has the power. We need to figure out how that person with the power is going to interact with the others, because it isn't a black box. It's actually a group of 6 or 12 or 10, typically 6 or 12. And from the 6 or 12, we have to figure out, okay, now those 6 or 12 personalities are going to have subgroups, and then maybe, and then have to come together. So who are going to be the leaders of the subgroups, and how are they going to interact? And what's your objective at the end of the day?
Do you think there's a distinction between power and responsibility?
Do you?
Sure.
Yeah, no, I do. I would have, I'm not sure it's not shades of gray, but I think responsibility is the same kind of thing. People who have responsibility in their jobs, in their lives, in their homes, I think are the kind of, leaders in the sense that you might be interested in or at least concerned about in these kinds of situations.
Yeah, and to your point, one of my, you can't do this all the time, depends on how many people you have, depends on how much time you have, but one of my favorite questions is, in what areas do you consider yourself a leader? That's a broad, open question. If you can ask that individually to the jurors, you get a lot of different answers to that. You have some people who say, I don't consider myself a leader. You have some people say, I'm a leader in my family. You have some people say, I'm a leader at work, and then you can query further on that. But I like the openness of that, because it really makes the juror think to themselves, okay, well, what areas of my life do I consider myself a leader? It's not a question people get often, and it kind of forces them to ponder.
Right, now that's not a question I would ask to the whole group.
Right, those are individual.
That would be an individual follow-up
exactly.
question.
Right.
So there are certain questions that are questions that that might be asked to identify the jurors. So you have these big open-ended, so you have sets of questions. Right? You have these big open-ended questions for the whole group, and then you have certain follow-up questions, and then you have follow-up questions for the individual potential jurors. Okay. So what do jobs mean? That's what I was going to focus on next. What kind of jobs are good jobs for the plaintiff, and what kind of jobs are good jobs for the defendant? And is there such a thing as good jurors for the plaintiff and good jurors for the defendant based on their jobs alone?
I think a lot of it's case-specific and fact-specific. Depends on the kind of case. And it may also depend on what part of the country you're in, too. But I think generally, again, back to the earlier point, if you've done the kind of thinking you need to do about your case and about your venue ahead of trial and ahead of time, you ought to be able to identify good jobs, bad jobs as surrogates for either attitudes or experiences that are more or less aligned with your case.
And I think that takes us to a good point, that to me, at a bare minimum, if you don't learn anything else about the people out there, I think you need to know what they do for a living. I think you need to know something about their educational background, and you need to know something about their family life. And if you can get jurors talking about those three things, you're going to get a fair amount of information that's going to tell you, that to me is sort of bare minimum. It's hard to answer the jobs question. I think it's too case specific, with the exception of teachers. I hate teachers. I don't ever want a teacher on a jury. Doesn't matter what side I'm on. Can't stand them. That's just me.
Okay, but why, Tara?
I'll tell you, and it kind of, no.
I would want the English professor.
Yeah, no. Sorry. As anybody teacher, I'm sorry if I'm offending anybody. It's just historically for me, the problem is too, for example, like a high school teacher. Teachers have a lot of leadership ability across the board, even a teacher of small kids. College professors for sure, high school teachers are the worst. And mostly it's just because you've got people who have good leadership skills, they've got good communication skills generally, and they're incredibly underpaid, undervalued, underappreciated.
That's exactly why I want them.
Well, but the problem is that you are going to have that leader on your jury, and to me, if they go with you, that's great. If they go against you for some reason, that's a negative. I'm fully willing to admit that this is a bias and prejudice on my side that is unfair on a certain level. Every time I've left a teacher on, it's been a mistake. All jury consultants have somebody that they don't like, that's just their. But I actually just had a patent case where we had a retired teacher and a principal that just got, the group to pick from was that bad. I ended up with a principal and a teacher, and we still prevailed. So maybe I'm coming out of this slump, I don't know.
Well, I have as a plaintiff, I believe there are certain professions that are indoctrinated into believing that there's no basis for bringing a lawsuit at any time ever. And that ideological indoctrination is so strong that I would never want a healthcare worker or somebody who works for an insurance company or an accountant or on my jury. I'm actually concerned, and those are the kinds of people that I would be particularly concerned about.
I agree.
That kind of fascinates me, because conventional wisdom had always been that helping professionals or helping professions were pro-plaintiff professions. But I wonder if the world's changed a bit.
Well, tort reform has changed the world quite a bit.
I agree.
I think that you cannot underestimate how much people hear through their work, through the internet, through meetings with other professionals of their same groups, constantly. And I think that tort reform is a huge force in impacting the kinds of jurors that you may want or not want on a jury. Has anybody else had that similar experience?
You left out an important one: engineers for plaintiffs, the worst. Too linear, too emotions for plaintiffs.
I agree with that, and your list as well is just sort of a general blanket. You don't want those occupations on the jury. I also agree. I think tort reform has impacted everybody all over. It's so prevalent in the news. I think it's very much a component, and it's huge with healthcare workers and people who've been dealing with hearing about medical malpractice lawsuits and insurance and how it's affecting rates and all that kind of stuff. And, I agree, like a nurse or the only caveat to that to me is, for example, maybe somebody who's a tech, I think, or a pharmacist. Or, I think there's some places where that changes a little bit, but overall, I think that's exactly right.
Well, then it's going to depend on what case you're trying, because if it's a case against Big Pharma, we never need a pharmacist, of course.
Right, yeah.
And if it's a case against a car company, I never want an engineer, certainly. And, and if it's, and if it's a malpractice case, I don't want any of them. The question a friend of mine said, who's been trying cases against big tobacco and winning big verdicts, said that he also excludes anyone that regularly attends church unless they're African American. He said that routine of regularly attending church, and I'm interested in Mark's comment about that. He thinks that those people are too regimented, and therefore he's concerned that they will not give a plaintiff's verdict.
I regularly attend church with me, and you would swap me on your church.
I know.
Yes, and I think that's...
Well, maybe I would, maybe I wouldn't. Depends.
And I think there's a lot of truth to that, but to me, it's for a different reason. It's really more goes to not a regimented person, it goes more to conservatism. Because anybody who's very conservative, to me, one of the things I want to know, if I'm working for the plaintiff, is do you watch Fox News? If you watch Fox News, I don't want you. If you like Bill O'Reilly, I'm done. You are number one strike, done, easy. I don't have to know anything else about you. And it really goes to, because there's so much indoctrination of lawsuits are ruining the world in that arena that it's just, So I think, yeah.
Right. That was my next question, it's not in this, but, so in the big tobacco cases, smoking's a topic that elicits really strong feelings and prejudices, and in our country, obviously, there's a highly charged political climate and a growing sentiment of the community who is voicing, a great concern about personal responsibility. People should take responsibility for themselves, and smoking cigarettes certainly strikes that nerve. So conversely, the argument can be made by the defendants that some people seek to blame others for their personal choices. So you need to figure out whether you have a social responsibility potential juror or a personal responsibility potential juror. And then once you figure that out, you have to ask a series of open-ended questions like, do you watch Fox News? And I wanted to ask, what other TV shows would you ask about to ferret out the personal responsibility versus social responsibility?
I wouldn't ask specifically about shows. I'd ask them what shows. I would ask them where do they get their news. That's the main one for me. And I agree with you that this personal responsibility versus social responsibility, the other way we think about it in social sciences, an internal locus of control versus an external locus of control, meaning there are people who think that it just, no matter what, they are absolutely 100% in control of their own destiny, and there's nothing that's going to happen to them, and that if something does, it's at least partially their fault. There's a continuum. And then you've got people who would never take responsibility for anything. Everything in the world has happened to them. That's the victim on the far end. And you do want to find out where people fall in that continuum. It's probably one of the most important things for me to try to ferret out of jurors on any case, because that's useful, I think.
And then, Bill, how do you get at those questions?
Oh, no, I think from a defense perspective, the challenge is finding that information without making it so obvious that it reveals your jurors. In many kinds of cases and in many venues, probably the first 100 people in the room, the majority of them are probably, vaguely or moderately defense-oriented. So in a way, the challenge becomes, identifying potentially difficult jurors without revealing defense jurors, because inevitably, and I'm sure it's from your perspective, but it seems like defense-oriented jurors are a little more doctrinaire and a little more willing to say, no, I could never, listen to the evidence and judge something like this. I've made up my mind and I'm gone. Whereas, and so you lose a big chunk of jurors who in reality would follow the law and would probably render a fair verdict. But So I think it's one of the biggest challenges. I want to know where people fall on what I call the responsibility entitlement spectrum.
So how do you, what questions do you ask?
Well, again, I think it's you have to figure out, I always want to know what people are doing at this point in their life and how they feel about it compared to other points in their life. Are they, I mean, happy is not the right word, content's not the right word, but are they comfortable with who they are, where they are, or are they not? Because people who are comfortable, again, it goes into this they feel like they're in control and they have some control over what's going on to them. They're the kind of people, I think, who are generally going to look at the evidence and decide the case based on the law. They're not, necessarily the eat your vegetables kind of juror, but also they're not on the entitlement, victim scale.
Yeah. And for me, I just see it comes out through the way they answer a lot of questions. I sort of cobble together their answers to a lot of questions to make that determination. I will say this, a good question that you can put on a jury questionnaire to get to this issue is, what should be done with the homeless? A, find them work, or B, find them a place to live. I mean, that tells you, that's a good question to get to whether they think,
But that's a pretty blunt instrument, though, too. I mean, there's
It
a lot.
is, but people they pick it. I mean, it's on a questionnaire, too, so you can look at it and see, and people will answer that very differently. Some people say, find them work.
What does that mean?
To me, find them work, that is a more internal locus of control. That's a pull yourself up by your bootstraps person. Find them a place to live is a little bit more of a, I used to want to say entitlement, you want to say, find them a place to live is, let's help, let's be caring, let's be, to me, those are two very different answers. But that's a jury questionnaire question.
Well, but those
That's tough to ask it out loud.
Those kinds of questions, too, depend on where you are. I mean, in a venue, I mean, one of the things that I think is so important to all of this is listening to the people in the venue. I mean, in today's world, local counsel isn't what it used to be. I mean, everybody's, law firms have offices all over the place. People try cases all over the country. You have MDLs, in generally larger places. The idea of trying important, high risk, high value cases in smaller parts of the country isn't what it used to be. But when it is, those are the kinds of questions that you have to really filter through your local counsel, because I can think of situations where somebody's compassion, you can be to use a phrase, you could be a compassionate, conservative, control-oriented person, but on paper, you might not look that way, or in voir dire, you might not look that way, but in some places where your local counsel can tell you, well, based on what I know about where this person lives, or where this person works, or what's happened in that community or that part of town over this period of time, this person may well be exactly the opposite of what they might appear to be on paper.
Right. And I think, too, the point you're raising is a good one, and that is all these questions, all these lines of inquiry we're talking about, none of it, you can't use any of it in a vacuum. To me, all the information you're gleaning on the jurors, each juror is a constellation of issues. There's going to be different ways they answer things that are even a little bit contradictory. You're just trying to get a read. And so for me, I would add the response to that question to all the other things I heard the juror saying. It just kind of helps me, just more information to help me make a determination about that juror.
Yeah. So then
Let me give a couple of examples of
question.
questions, areas of questioning, and see if that will elicit some further thoughts from you. So prior lawsuits, not satisfied with the results. How many of you have either been a plaintiff or a defendant in a lawsuit? See the number of hands. Anything about your experience that left a bad taste in your mouth that might impact on your ability to serve as a juror in this case? Now that will definitely tell you, get you, I think, a response that will tell you that they are angry at the system and therefore will be more of a personal responsibility kind of a juror. Another set of questions might be, we all come in here with life experiences. We did not check them at the door today, and many of us have opinions and attitudes about smokers. I understand that you haven't heard any evidence yet, so all you know about this case is that it's about a smoker who developed lung cancer and emphysema and died, and his family is now suing the tobacco company. How many of you may feel that smokers made a choice to smoke, and if they get ill because of that choice, they should not blame the tobacco company for their choices? It's the basic principle of personal responsibility. You might see people who will then raise their hands.
Absolutely.
And despite your best efforts, you cannot put your feelings aside that those smokers made that choice and that it was their responsibility to stop smoking. You see them raise their hands, and it's reasonable that you have this very strong feeling. We respect people that have really strong feelings, right? Because you want to both enable them to speak and also to ratify their sense of firmness in their belief, because you really want to encourage them to tell you.
And I think you're raising a really good point. With the exclusion of the two people up here, one of the things I've found is that jury selection is one of the things that lawyers are the worst at. And they're just the worst at it. And no offense to all the lawyers I work for and with, but part of the reason I think that it's so challenging is because a big part of jury selection is eliciting information that is counter to what you are going to be arguing and putting forward for the rest of the trial. I think that's very uncomfortable for a lot of lawyers, and I think getting comfortable with doing that is a huge skill, and I think it's a challenging skill to be able to cultivate. But that's the point: is eliciting information that is counter to your case, and then having the juror ratify what they're saying, so that you know where they stand. And, it's okay if you feel that way, sir. It's okay, and continuing through the panel that way. But I watch lawyers all the time struggle with that, because they turn around sometimes and try to argue the juror back to their perspective, because I think that's a lot of times what you do for the rest of the trial. But I'd be interested in your thoughts on if you were ever uncomfortable with that, if maybe even earlier in your career, and then how you overcame that, because I see that a lot as a struggle.
I think it is a struggle, because you will ask the juror, you say, typically, this is a case about an automobile accident, and our client died. Our client's little boy died in the automobile accident, and of course, everyone's comfortable with awarding damages that would compensate people for their medical bills and their funeral expenses. I think we all can agree on that. I think that's an easy one. But my Aunt Susie and I have been debating this at home all the time, especially last night. On July 4th, we were talking about the fact that she has a tough time giving people money for mental anguish. How do you compensate somebody for losing a loved one? There's just no money that's appropriate, and she feels offended by plaintiffs coming into court and asking for money. And she holds that belief really firmly. So as you imagine, it's a really lively conversation at July 4th along with the fireworks. So I really want to ask you, how do you feel about that? Do you feel that you can fairly compensate someone for mental anguish? And then you've ratified, it's okay to think that you don't want to give money for that. That's fine. Because you've said, my family doesn't do it, that's okay. But we're here, we don't believe that's right, but we want to know what your belief is, and we want to know if you hold it firmly. That way, I think you get at those jurors. Now, that's something that is incredibly offensive to me, and honestly would have freaked me out 10 years ago, to have somebody actually say that to me, in a courtroom, when I'm there having worked so hard to get there with my clients and believe so much in their cause. But I realize that you have to honestly talk to that person, get them to tell you what they really think, so you can get rid of them. Right. And they can't hurt your case.
And I think the important thing is to say, now, does anybody here believe, and that's okay, a lot of people feel that way. A lot of people feel that awarding damages for mental anguish is inappropriate. Do you feel that way? And then you say yes, and you explain it to me, and then I need to look you square in the face and say, thank you very much. I appreciate that. Anybody else? Does anybody else feel that way? And then you look right at that juror, and you let them tell you why they think that what you're going to be putting forward the rest of the trial is absolutely ridiculous, and you look them right in the face and say, Thank you very much.
And-
Thank you. And
but
it's
you-
important.
But you need to do two things. You need to show a lot of respect to the jurors that you despise, and because you want to get the information out from all the other jurors in the room.
That's right.
So you're not poisoning the well, per se, which is a slide I have later, because you're eliciting this information, but rather you're showing respect to that person, and you're also allowing other people to tell you what they think. So that allows people who are less strong to tell you, or maybe more shy, to tell you what their beliefs are. And it sort of allows for, and also gets sort of a group effort, a social rapport. People will do things if everybody else will do it. We all respond in this sort of to peer pressure. So if everybody else is saying how they really feel about this, you'll get a real answer out of juror number 12.
Yeah, I do a lot of work with a lawyer in Las Vegas who's just an amazingly skilled lawyer at jury selection. I learn from him every time I'm there with him, and it's modified Arizona method, so there's 18 jurors in the box at a time, so he's only talking to 18, so he's able to do very individualized questioning of them, and it's remarkable to me, the rapport that he builds just by being incredibly respectful. I think even the jurors that absolutely can't stand him because we're on the plaintiff side and we're asking for literally $1 billion in a case last year, I mean, just huge amounts of money, and even the jurors that just can't stand the case, I think they really still like him because he treats everybody so respectfully. I've never seen his eyes move off of a juror that he was talking to. He never darts. I mean, when he is talking to that juror, he is just laser focused on them, and it's really the effect that seems to have on the individual jurors, and in fact, I think the way they all then perceive him is really profound. He's just. And the truth is, as much as he's an absolute dyed-in-the-wool, true believer plaintiff's lawyer, but he loves juries. He loves juries, loves people, loves talking to them, even if they disagree with his perspective. And I think that's a big part of it too.
I think that's one of the hardest. It's the piece of trial practice and even voir dire that nobody spends much time talking about, but it's probably one of the fundamental keys to it. Is just your physical presence and your interaction with people. And as lawyers, we're not all, we're trained to communicate, and we're advocates, and people, pay us, hundreds of dollars an hour to do that. But if you stop and think about what that means, I think sometimes we don't do it as well as we should, and it really is exposed in voir dire. I mean, in voir dire, you're standing there with nothing really between you and the person you're talking to. You don't have a podium usually, you don't have the cross-examination outline, you don't have exhibits, you don't have a witness that you can use as a foil. It's just you and that person. And that's a very vulnerable, kind of uncomfortable position to be in, especially when you're talking about things that your audience knows you disagree with. And so I think, to Tara's point, I think a lot of it is rehearsal. I mean, it's being able to stand in front of a mirror, or stand in front of your children, or stand in front of your friends, or stand in front of people who disagree with you, and be an active listener, listen to them in a way that makes them believe you're actually listening to them, not just thinking about your next question. And then responding to them in a way that respects them and kind of empowers them, as opposed to belittles or alienates them. And I think as I get older, and as I watch people who do this very well, I think it's easy to say, oh, they're instinctive. I mean, but I think people like David Boies, people like Mark Lanier, people like anybody that you've seen who does this. A part of it is instinct, and a part of it is actually just something we could all learn how to do and rehearse and get better at, but we never spend the time doing it.
And to your point, I'll just say it's Robert Eglett that I'm talking about in Las Vegas, and he has probably read every jury and trial consulting book that there is. I mean, he made a bad jury selection decision years ago, and he swore to God he was never going to do it again, and he just took it upon himself to really learn this process, and it's taken a tremendous amount of sort of study and effort on his part. This is not something you just stand up and are great at. The other thing I would touch on is, it's interesting to me to watch different lawyers do this, because I've kind of come to realize there's two kinds of lawyers when it comes to, well, I mean, trying a case. There's lawyers who love juries and want to get their case to a jury and love people and trust juries, and then there's lawyers who are afraid of juries. And I think you have to kind of ask yourself, where do you fall in that, and where do you want to be? Because I think, to me, I see it as kind of, you're on one side or the other. And I think that the lawyers that really love juries, trust people, trust the jury system, trust that jury's going to make the right decision, the lawyers that are afraid of juries, the jurors can smell that. They can tell. And it's just I think it's a different dynamic. That's just.
But that's not being afraid, but that's not being, that there's a piece there that I want to just pick up. That's not being afraid of or nervous when you're initially
No,
presenting.
no. It's not
Because
trusting them.
it's not, right, it's not trusting them.
Right.
It's not trusting yourself, because there's a piece of us, there are very sophisticated lawyers here who probably never have this experience, but I can never come out in a jury room and get a sentence out initially. I can't stand up at a podium in the Eighth Circuit, Supreme Court, wherever, without getting the first sentence that comes out, blah, 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 because I'm nervous. And so I just have come to the point where I just say, I'm really sorry, I'm really nervous. This really matters to me. And then it instantly brings everybody in the room on your side. And it's one of those things that it's really important, that I think that you need to sort of be who you are in this. That's going to be repeated all day long, I know, and you've all heard that a million times, but just you have to be who you are in these situations. I can't be Mark Lanier as much as I would love to be, or David Boies. I'm stuck with me, so I'll just do the best I can do.
I have an observation and a question, if you just time. I like that, where do you get your news question? That'll tell you a lot. A lot of times, my favorite question to get the jurors to open up again is to ask them, tell us something that you're proud of. And then, so to help them know that I mean that as an open-ended question, I'll say, well, I'm proud of my two daughters. But you may be proud that you've been married 50 years. You may be proud that you raised dogs. Then you get all kinds of responses. You'll people say, well, I'm proud that I've lived 75 years. I never had to sue anybody. I was always able to work it out.
Right.
But,
that's great.
Get people going, and they're bragging on themselves. I'm proud that I've been married 50 years, things like that. And I also had a question. Do you think there's value in kind of assaulting the voir dire with your theme? I mean, the obvious place is the opening statement, but then we'll see it coming. Do you have any views about kind of weaving that into your voir dire? I had a case where I represent defendants, heavy equipment or pharmaceuticals, and something like the weave in is personal responsibility. There were a lot of women on the jury, and I would ask them, I said, well, have any of you ever had this experience? When I was a younger man, my wife would always tell me, honey, I love you, but I can't tell you anything. You don't listen. And or if you have a boyfriend, girl, all the ladies' hands, went up, and I said, the term what is, can't tell you nothing. And so I was going to weave that into our case later on, because the guy got his arm twisted off in a way that was stupid, but you can't say stupid, but it was careless to the point of
Stupid. Right.
And so, after the voir dire, all the women were walking past, had to walk past plaintiff's table to pass mine, and they all ignored him, and they all looked at me and gave me one of those, trident smiles. And it went that way. I never once had to say you brought it on yourself, but they were saying that.
Right, because you introduced the concept. I mean, I think you have to introduce all of these concepts.
It didn't look like I was indoctrinating them.
Right, I think you have.
Just tied into their personal experience. And as a man, I believe that's true. I didn't believe it was true until I raised $2. And then I saw how hard it made me begin to see what a knucklehead I'd been all these years. All these things that my wife been telling me all along, but then I could hear the same things my daughters were now telling me.
Right. No, I think that's really helpful, but how would you turn that around? If you were now the plaintiff's counsel, how would you turn that around?
I wouldn't worry about the plaintiff. But if I thought on it, there's a way to do it. I mean, you got a lot of advantages just going in. as a plaintiff.
But-
You're not ham-handed.
No, I think there are 3 or 4 or 5 topics that you can introduce in a voir dire that are consistent with your themes. I mean, somebody in that panel is going to work for a big corporation, and it lets you, I see you work at Acme, so-and-so. How long have you worked there? How big is it? How do you feel about your job? Well, why have you stayed there so long? How do you feel about the way the company treats you and other workers? I mean, so I'm going through the whole big company narrative with a juror who may give me answers that I don't like, but allow me to start introducing the idea that just because a company's big doesn't mean, and then we're eventually going to get to the questions that commit you to giving a big company the same kind of consideration you'd give to a small company or an individual. But along the way, I've started to introduce some ideas and some thoughts about what companies do that are right, what companies do that are wrong, and how that may or may not connect to the lawsuit. And there are any number of other issues you can do that with people.
I just thought the answer to your question is that you lied to me. That'll even help you to trump personal responsibility. If you can find an area in the case where you can say that this party lied to that party, people don't like being lied to.
Right, people don't like rule breakers.
Or whatever kind of.
Right, if that's your thing, if you're a plaintiff.
Plaintiff is lying, you got something. Defendant's lying, you got something.
Right, I mean, I think if you're a plaintiff and your theme is rule breakers, that's a.
No, that's different from.
That's also a good
You
one.
lied to me is different from breaking a rule. Because a rule might be, well, don't cross, a rule doesn't have to have a moral component to it. You lied to me has a moral component to it.
That's interesting. That's good to know. I wanted to move on a little bit to juror questionnaire because it's a big hot topic lately. There are 2 different kinds of juror. I'm just going to sort of go through this a little bit. There are 2 different kinds of juror questionnaires. There's a juror qualification questionnaire that can be just a simple, background information, and it's standard. If there's a standard Pennsylvania one, there's a standard California one. If you go online, just go into civil court questionnaire, you pull it up. There's one, if there's a Pennsylvania one, same thing, you just pull it up. I haven't seen a New York one, but I think that there must be some equivalent. I just haven't seen it. There's certainly a Texas one that I've seen online. So you just need to go in and take a look at it to see what questions get asked. And then you can ask your judge to individualize the questionnaire for your veneer panel. In California, they like to do it because it's quicker. It saves time, and as you know, the California courts are crunched right now. I don't know if people will do it here in New York. I was going to actually ask this question tomorrow in court, whether they'll use a questionnaire, whether they'll send it out in advance to the potential panel and let them come in with it so we can have it before we actually select. So I don't know if they'll allow us to do that here, if that's what we do in California. So, but it's very useful. And then the question is then, using an individualized questionnaire, the questions are, you have to know what kinds of questions to put in the questionnaire. I mean, the proponents of questionnaires claim that they're huge fans of them. Elicits more honest responses, that you can get more independent responses, that you can get more complete information and protects their privacy. But the question is, I think from my question to you, Tara, is what kinds of questions do you put in the questionnaire that will elicit real answers, that will help you?
It depends. That depends completely on the case. I'll say this about, used to be, at least on a lot of big cases too, where we'd have these massive questionnaires. I mean, just massive. I'm actually not a big fan of massive questionnaires. I think they annoy the jurors. I think you can get a lot of information from a 1-page questionnaire. You can get a lot of information from a 3-page questionnaire. And we're talking about kind of a change of perspective. I used to be a little bit more of the idea that you wanted to put some sort of programmatic questions on there. I don't believe that anymore. I think you just want to get as much information as you can. And for me, most of the questions, if they're aside from employment and education and things like that, if it's questions beyond that, that comes generally right out of pretrial research. So if we've done 2 mock trials on a big patent case, for example, we have probably come up with a couple of questions that we've asked on our intake questionnaires that we've gone back and looked at and found out that those questions are, predictive is probably a strong word, but can help us identify, say, pro-plaintiff jurors if we're on the defense. And so that's another way to use pretrial research to be really helpful to you, is make sure you've got kind of a kitchen sink intake questionnaire, asking every question you can possibly imagine, because you'll be able to go back after you finish the focus group mock trial and say, look, everybody who went pro-plaintiff answered this question this way. And sometimes they're really kind of strange questions. We had one where everybody that said their favorite subject in school was math. It was somebody, sometimes you can find some pretty benign questions to add to the questionnaire, and then the other side may not really even understand what that question is telling you. So, but, what kinds of, I just like to know the basic stuff, have you been sued? Have you been on a jury? What was that about? How, employment, family life, education. I definitely want to know about your spouse. I want to know what your spouse does for a living. That's one that is overlooked to me. If you don't know what the spouse does, you're missing out. I think that's important. I'm trying to think just basic stuff. I just did a 1-page in a case that we had. And then you can do some case-specific things. In these patent cases, have you ever filed a patent? Do you know anybody that's ever filed a patent? Have you ever invented anything? Have you ever been accused of taking something that didn't belong to you? Things like that. But I think it's case by case.
I'm less enamored with them than I used to be. In the old days, if you did jury research, you could develop a programmatic questionnaire. You could persuade the court that it would save time and avoid a lot of voir dire by having people fill out a questionnaire. You had a consultant who could crunch the questionnaires with you, and you got some information that was or wasn't actually useful, and there's no way to know. In today's world, from a defense plaintiff's perspective, I hate to kind of divide this into defense plaintiff's perspective, because I think trial practice is trial practice regardless of who you're representing. Everybody does jury research now. Everybody has consultants. Everybody does things that 15, 20 years ago only defendants generally did. Now, quite frankly, a lot of the plaintiff's lawyers do it better and more often than some of the defendants do, because the defendants and on the client side, they don't want to pay for it anymore. So the questionnaires have become kind of a push. I don't think it's really an advantage or disadvantage to have one, and I'm not sure it reveals as much as you can now find in a relatively short period of time online about people. If I have your name, your address, your employer, and maybe a little bit more about you, I can send two paralegals out in the hall in an hour with a couple laptops, and I can figure out what candidates you've given political contributions to. I can probably find some things on if you have a Facebook page without even being your friend, I can find out some things about you. I can go to LinkedIn, I can Google, I can develop an amazing amount of information that you used to need the questionnaire for, that I can get independent of that, and it's probably better information. We had an example recently with a juror who in oral voir dire gave some answers that everybody thought were negative and likely put him on the strike list. He was on the strike list. His questionnaire, made him seem like a nondescript guy. Paralegal comes in 20 minutes later, says he's contributed to Scott Brown's campaign. This was Massachusetts. He gave money to the guy that ran for Senate, Scott Brown. He's given money to the Reagan Library. He's a veteran. He's got kids who are decorated veterans, and he ended up on the jury, and he ended up a very, very strong defense juror. Without that information, we would have struck him. So there's a lot out there now that's easier to access than trying to extract reliable information from a questionnaire. So, I'm not opposed to it, but I'm just kind of agnostic about it.
Well, I think you need enough information from the short questionnaire to do the Facebook, LinkedIn, internet research that you need to do now. So I think that's exactly the point. I think that's why I said the shorter the better. I think you need, and no matter who's going to get, whether the judge is going to allow you to do a voir dire that's very extensive, or the judge is going to do it himself or herself and give you an hour. You need to get the information, so you can get the information about the jurors.
And just as a sort of nuts and bolts comment, I would say this too. I think it used to be back when jury questionnaires first started to kind of come into use, the judges, at least my experiences, used to be more willing to get involved in the process. I think now, if you want to do a jury questionnaire, you need to make it simple. You need to get agreement from the other side first, and then go to the court with it together. I don't think, judges used to be willing to kind of get in the middle of that they seem to be more willing to get in the middle and argue out questions and stuff. I haven't seen a judge do that in years. So if you want to do it, that's fine. Draft it, send it to the other side, fight back and forth on it, agree to it, and then take it to the court. I think that's your best bet at getting the court to allow it. And then, of course, find out whether the court's allowed questionnaires in the past and what length and, that kind of thing.
And if there's a standard that the judge prefers.
Right.
I think that's our time's up, so.
I think, is that
10:30?
right? So should we take a? We can,
Okay.
okay, well, yeah, we could do some, we could do some questions on this, jury selection and voir dire.
Okay,
Yes.
this is my heirs and agree.
You mentioned that we should identify the leader, but what is the purpose of doing that? Where do you go after?
Okay, well, then you have to figure out whether the leader is going to be for you or against you. So then you have to go to the second area of inquiry, which is to figure out whether or not this potential juror is going to be a pro-corporation juror, pro-defense juror, or plaintiff's juror. And then, because once you know, then you know whether or not you want to keep that juror, because conceivably, that leader will be somebody who will be terrific for you. I mean, under my story, actually, the deputy prison warden would be terrific for me if he answers certain questions, certain other questions really well, or maybe the guy from McDonald's. So that's why I want to know both. I want to know whether he's going to be a leader and if he's going to help me in the room. That's because if he's not, he would be more important for me to strike off than an insurance adjuster who's a meek, mild, mellow, quiet person who's going to go with the flow. So the defense juror that's going to go with the flow is much less important to me than the leader, if the leader is going to be a problem.
Yeah, the one thing, too, I'd add to this that I just was thinking about, the one thing that I don't love demographics in terms of making just broad decisions, older people are better this way, younger people. But the one thing, I've done a lot of research and writing and speaking on the generations and the different generations, and now with the millennials, which at this point now is, I think, anybody under like 35. So it's not just people in their 20s anymore. The millennials, are getting older. And there's some real dynamics with the younger jurors that are really they go against conventional wisdom. For example, even though I don't love demographics, I mean, to me, younger people are, as a general premise, pretty good defense jurors. And that's, we would never have said that 15 years ago.
I think
just would never have said that.
I think that there are groups like that, they're very polarized and they won't back down, but I think the problem is, in that group and other groups, it's hard to figure out, it's about a 50-50 split, and it's hard to figure out who's who in that group. That's the challenge with those kinds of demographics.
Yeah. I see, I mean, granted, I do, 70% of what I do now is intellectual property, but if I'm on the plaintiff side, I'm not taking somebody under 35, just not doing it. I mean, I see it over and over and over and over and over again in mock trials. And it's wild because it's one of the only demographics that I do look pretty closely at. But I think beyond just whether you want them or you don't want them, I think there's some attitudes and beliefs and value systems that are present in a lot of the younger jurors that kind of run counter to what I think we would have thought of younger people 10 or 15 years ago. And so I think it's worth doing a little bit of reading and paying attention on that. The other thing that I think is interesting is that group of people, doesn't matter. Hey, I'm 25 years old, but I have no problem saying exactly how I feel. There's probably people in this room who have kids that age. They have no sense that their opinion is not as important as anybody else in the room. And I think that's, there's some components of that are just things to keep in mind.
I mean, you're in a room in most law firms with, a room full of 50-year-old white men talking about how you're going to try a case. You're in the wrong room, because you're trying a case to a bunch of people who don't think like you, haven't lived like you, and really don't don't have the same values and life experience you have. It kind of begs the question of how you put together a defense or any kind of trial plan in today's world, and you've really got to have different people from different parts of the world and different generations, because it's a very, very different group of people.
Right. And I just think it's easy to apply the wrong sort of conventional wisdom to young people. You know, young people these days are not the same thing as somebody saying 10 or 15 years ago, young people these days. And it's worth taking some time to kind of acquaint yourself with some of those theories. And
Well, I think you need to persuade yourself. I think that's, not to go full circle, I think that you do need to do some kind of pretrial research, focus group research, to see who will respond to your case and who will respond to the defendant's case. When you do the pretrial research, my experience is it's good to do the research where the defendant's case is a little bit stronger than your case, to just tweak it a little bit so you really will get at the issues. I mean, you're not going to do a 2-week trial to a focus group or to an e-jury group. You're only going to do a teeny program, so you want to pull out the facts that you think will really resonate on each side.
yeah, we always say you want to test your most reasonable worst-case scenario.
And then we talked about this a little bit in terms of the questions. I don't know if you want to move on to this, the questions that you actually ask and how you ask the questions, because I think this is as important as all the other parts of picking a jury. Just like the gentleman just said about, I asked them what they're most proud of, and the way I say it is I give them an experience from my own, and then I ask it. So I would ask, do you think that, so instead of asking, do you think that large corporations, would be an employment termination case, right? Do you think that large corporations fire employees without good reason? When that question was used in a social science study, they got, 60% said yes, 40% said no. And then of the 60%, you couldn't really tell where they fell out. So, and they say, why do you think that? And you didn't really get a real answer, and so you couldn't figure out where the firm beliefs were and where they weren't. But when they did the same study and they asked this question, do you think that some large corporations fire employees without good reason? Why do you think that? They got many, many, many more people, they got almost 95% of that 60% group said absolutely yes, and 5% said no. I'm not sure why. So the greedy corporation group, you were more able to identify the greedy corporation group from the pro corporation group. So you were able to identify the pro defense jurors from the pro plaintiffs jurors. I mean, that is certainly the idea. I mean, the question is, and this is one of the other issues that I think we all talk about among ourselves, how much will I poison the well? How much will I pollute my whole jury panel by asking these questions and getting into a discussion about, not awarding money for mental anguish? I mean, from a plaintiff's perspective, that's the biggest concern. I don't know what the defense, I have 2 poisoned wells here for you.
Oh, I think you can't be afraid to talk about those kinds of things because the jury's going to talk about them. You can't be afraid to talk with a jury about anything they're going to talk about in deliberations. And the fact that you're not afraid to talk about it, and the fact that you're willing to accept people's thoughts on it in a non-judgmental way, I think is a good way to argue your case as a defendant. I mean, you're basically saying, I'm not afraid of these facts because I'm going to demonstrate to you why the plaintiff won't prove that they're entitled, to recover, that they can connect the facts. So I think I'm probably in a minority of defense lawyers who feel that way, but I think you should not be afraid to talk about anything in front of the panel.
And I understand the concern. I mean, I really think the idea of poisoning the well is kind of a myth. I think people are sitting there, they believe what they believe. You want to just find out what it is. I think. Now, I say that, and it just sort of depends. I've seen lengthy jury selections where probably some of the people were a little bit enlightened on something. Maybe there was something that they hadn't really thought about it, and because of the discussion that ensued, maybe they thought about it. But did it did it change them? Did it take them in a polar direction from where they came into the box? Doubtful. So I think the idea of poisoning the well per se is not something to worry about. I agree. You got to talk about these issues.
So then the last thing is that you might want to, once you identify the jurors who are bad for you, you don't want to let the other side rehabilitate them. Once you have isolated them and figured out who they are, these are potential questions about companies, where you believe consumers should know and assume that companies are going to be untruthful about the safety of their products. In other words, how many of you believe that regardless of any false or misleading information a company provides, the consumer is 100% responsible for the harm he or she suffers from using the product because they knew when they took the product that there would be risks? Now you've identified that juror. So now you definitely want to, find out who's the general personal responsibility juror, who's going to be responsible for their actions. And now you've identified the jurors, so you want to make sure you tie them down and don't let the other side rehabilitate them, or else you will be responsible for your actions.
I think the other point, too, that's kind of going on to this is, and I'll give you an example. So I think it's so important not to stumble into arguing jurors over to your side. We've talked a lot about this. You want to elicit information that may be uncomfortable. Once you've done that, so the example in a patent case, for example, is there's two burdens of proof. So there's preponderance of the evidence on infringement, but there's clear and convincing evidence on invalidity. So on the plaintiff side, you want to get up and say, now, we have to prove infringement by preponderance of the evidence. The defense has to prove, they're bringing claim to say our patent is invalid. They have to prove that by clear and convincing evidence. Is there anybody here that just thinks that's unfair? Well, you're going to get a bunch of hands, and then you elicit this information from them as to why they think that's unfair. And from our perspective, that on the plaintiff side, in a case like that, that's good. Now, once you've figured that out, you're in federal court, you may or may not get them for cause, but at least you know that there are some people that are now predisposed to be kind of thinking that the defense is getting a raw deal. Once you've got them all identified, once you're done with that, then you come back and say, now there's a reason for that. The reason is Patent and Trademark Office, when they grant a patent, that patent then has a presumption of validity. It's somewhat like a presumption of innocence. You have to prove beyond a reasonable doubt if you're going to bring a criminal case against somebody because there's a presumption of innocence. Same thing in the patent world. There's a presumption of validity. That's why the burden of proof is higher to take away somebody's patent. So then you come back and explain why there's the difference, but you don't do that at the outset because then you wouldn't get anybody raising their hands. And so, I think there's other areas where, and maybe you guys can think of an example in your worlds where you want to make sure that you don't over-explain. But then once you've gotten identification of the jurors are problematic for you, you do need to come back and explain why something is the way it is for all the jurors that are remaining, just to make sure that they're clear. I don't know if I'm making sense on that. And a lot of that is structure. I think it's very tempting. Like, I've seen lawyers try to do this, and they just can't help themselves. They have to explain why those burdens are different at the outset, but that makes it, then now all of a sudden it's a little bit of a useless exercise. So.
I think that it gets back to trusting your jurors. You've got to trust the jury. You've got to trust them that they'll listen, that they'll put two and two together and get to four, and that they'll do it in a way that makes sense to them, not that is the way you think they should do it. Which is another way of saying, I think the one thing you can't do in voir dire is to alienate your jurors. If you alienate a juror in voir dire, you run a very large risk. The rest of that jury is going to hold that against you when and if it comes time to make the hard decisions they have to make about credibility. It gets very hard in places where you have to make your strikes in open court in front of the veneer. Everybody starts wondering, why did you strike this person, not that person? Those kinds of things. But you cannot alienate people during voir dire. And the way you alienate people in voir dire is the same way you do it in the rest of your life. You're either dismissive, or you're disinterested, or you're disrespectful, or you just won't listen, as somebody said earlier. And again, that's not trial practice. That's life lessons. But I think this is the part of trial practice where it has the most effect.
I think that a carry on to that I've seen happen, and this is something that's a little bit of a new observation of mine. I'm trying to work it in with some of the work I'm doing with my lawyers is so often you're so focused on the people that are really talking, either pro-plaintiff or pro-defense, that once you make your strikes, you look up and you've got 8 or 10 or 12 people in the box who you don't have any information on, because the people that you struck and the people that your opposition struck are the people that talk the most. And I think that's a real danger. I think it's important to try to talk to everybody and get as much information as you can from everybody, so that once you've got that jury impaneled and you've made your strikes, you've heard from those people, you've built some connection with those people, because, oftentimes those folks that get left are the ones who are a little more quiet, they didn't say as much, they kind of hid. And, every once in a while, I've been on cases where you look up and you go, I don't know that much about those people that are left in the box. And that's not where you want to be at the outset of a trial.
Sure.
Yeah, I just had a question. I think what you were saying is really important. You have to give them license to talk, and license to feel that anything that they say is not foolish or looked down upon. And that question that you said about your aunt, Susie, I believe, of 4th of July, you said some people believe this, other people believe this. Which one do you fall into? That gives them the freedom to say, I agree with this, I agree with that. Is there anything that you do in your introductory statement to also give them license to talk, to say that, listen, whatever you say is not going to be looked down upon, it's not going to be wrong. We just want to know what your opinion is, or your belief.
I think I just say that. I think I just say it as bluntly as that.
Yeah.
I just say this is really a process for us to find a jury who's fair and who can be fair here. And a lot of times we think we can be fair, but really we can't, because we have some beliefs that we don't even acknowledge, even to ourselves. So we're trying to sort of figure that out now, and figure out whether or not that you can be fair in this context. And I might change the language of that a little bit, but that's pretty much what I say. Because I think that we can all acknowledge that sometimes we don't know ourselves. We think we're going to be one way, but we really are another way, and we want to find that out.